So wanted to welcome everyone to the next session in the Berkeley Center for Law and Technology's career series. Once again, we're fortunate that Wilson Sonsini donated a little more time to us to explain practice groups and broadly, and then talk a little bit about their firm and then why that might be different from other firms. So today we have two attorneys out of the Century City office of Wilson, Lisa Zhang. Lisa is a partner in that office. You'll get to hear quite a bit about the breadth of her career, but she's in a group, Internet Strategy and Litigation, and I think we'll talk about what that means, because you won't see that phrase in a lot of other firms, and what that means for Wilson to focus on that. And Russell Kostelak. Russell is also in the Century City office, senior associate there. Help us understand a little bit about the difference between associate day and a partner day in big law as a whole, and in this area as a whole, and plus a little bit different practice than Lisa, overlapping and different. And I think those are kind of what makes the practice of law interesting. You can share practices in some ways, but then have differences in others. So it develops lawyers in different ways. So with that, I wanted to thank you both for your time and for helping us put this material out there.
Thanks for having us, Wayne. It's great to be here with you.
So first question, like I mentioned, this, you're both in a group called the Internet Strategy and Litigation Group. And for a lot of new law students, they only see groups like litigation and corporate. This really detailed group around internet strategy and litigation is going to be new for most people. In fact, it was new for me, and I spent my life in Silicon Valley. Can you tell us a little bit about what it is and what it does and what it enables you to do?
Yeah, so as internet strategy lawyers, we are first and foremost partners to technology and consumer companies that are facing complex legal issues, issues involving technology and the internet. Fundamentally. So our firm's Internet Strategy Group litigates and provides counseling in a range of practice areas, including copyrights, trademarks, trade secrets, privacy, First Amendment, advertising, regulatory issues, and so on, all in the tech and internet space. So, for example, we defend companies that find themselves in lawsuits over things that third-party users do on their websites, whether that's through asserting a First Amendment defense or on the basis of what's called Section 230 immunity from civil liability. We also handle copyright and trademark disputes over content that's posted to online platforms, most commonly by third-party users. And many of these issues will involve platform immunity under the Digital Millennium Copyright Act, or DMCA's safe harbor. And, we also litigate class action privacy claims over the ways that websites handle their users' data. These are just a few of the types of issues that we can help our clients with. I'll note that while the focus of our group is in litigation, we also advise our clients on these very same issues if they find themselves in tricky situations, and often also in the course of their everyday business operations. The idea here is to help our clients avoid getting into litigation down the road. That, in a nutshell, is what we do as internet strategy lawyers.
So I'd love to pick up on that last piece. You mentioned it in the beginning, that you have litigation and counseling. And I think often the stereotype is trial lawyers are trial lawyers. That's all they do. They go to court, they write briefs, they maybe my personal scars from litigating for too many years, they bicker with each other, but people don't think of them as advisors and counselors. How does that work in your world, that you're actually engaging with them in litigation avoidance? What does that look like day to day?
Well, it might be, for example, we have, let's say a client has hired someone and they receive a demand letter from their competitor saying, hey, you hired someone who was very key to our business. We believe that this person has taken trade secret information, proprietary information that belongs to us, the competitor, and is using it within your company. And this is at the pre-litigation stage, and the client will come to us and say, what do we do about this? How do we diffuse this before it becomes litigation? How do we basically, how do we navigate the waters here? It may also come up in a situation where we're setting forth best practices for avoiding even that kind of a situation. So even before we get to a pre-litigation dispute, it can look like a lot of different, it can take a lot of different shapes and forms. Maybe Russell, since your practice is, overlapping, but also slightly different, you might speak to some of the areas that you've counseled in as well.
Sure. Lisa mentioned the Digital Millennium Copyright Act earlier in her initial spiel. That Digital Millennium Copyright Act gives certain protections to online service providers if they meet certain requirements. So a lot of what we do on the non-litigation side is helping online service providers ensure that they are meeting those requirements, so that way they can obtain the benefits and the protections that the law provides. It's better to do that from the outset, so that way when a litigation occurs, they can say, well, we've done X, Y, and Z, therefore we get the protections afforded by the Digital Millennium Copyright Act. If you've done your due diligence beforehand, the potential litigation that comes down the road can be resolved easier and hopefully quicker.
So when I look at this group and I think about the overlap, it's litigation, it's the counseling side, and everything you're doing from the copyright side to the patent side to the Section 230 side. Does your group overlap with other groups like patent litigation or copyright litigation, or is everything all put together under this Internet Strategy and Litigation group?
Sometimes we will actually overlap and we'll collaborate on cases together. We have, in addition to cross-office staffing, we also do have cross-practice staffing on certain kinds of cases. I myself started out as a patent litigator when I was a first-year associate, and later, transitioned to the Internet Strategy group. But because of my background, I will often, work with my colleagues in the patent litigation group. We may work together on a case. I may provide input on areas that are adjacent to the patent litigation issues that their clients are working with. We definitely do collaborate, and there is crossover. And there are other areas too, like copyright and trademark litigation. And on top of that, there are also issues that will sometimes, emerge in the same matter that are related to other groups, like our complex litigation group, potentially commercial issues. For example, you may have trade secret issues that come up in parallel with unfair competition or unfair business practices claims, and we'll work together with our, complex litigators on those kinds of matters.
A part of it has to do, I think, Wayne, with the breadth of our practice. We are internet litigators. Pretty much every single company that you can think of has some sort of internet presence nowadays. So because of that, our group kind of isn't pigeonholed into one thing. We solve problems that are focused on technology, and that can happen over the internet. 30 years ago, that was tiny. Now that's everywhere. That means that we can offer services to anyone, and in a wide variety of different problems that happen on the technology and internet sphere. So because we cast that wide net just by the very definition of what we do, we tend to overlap with many other different subgroups within the firm, and tend to kind of collapse many different legal groups within just the boundaries of our group here at Wilson.
Well, Wilson is obviously just a giant in the tech space and life sciences. I don't mean to sell them short there, but when we think about who they represent, it has a reputation for those that have been around a long time of representing a lot of small emerging companies that eventually turn into giant industry leaders. So where does your client base fall? Is it emerging companies or giant companies that have come up through the ranks in Silicon Valley? Or sorry, I'm Silicon Valley centric in the world. Anywhere. Since you're in Century City, I don't mean to cast bad vibes toward that part of the world. But what do your clients look like in terms of the technology world?
Yeah, I think it's all of the above.
Okay.
I mean, as an internet focus group, as a technology focus group, it should come as no surprise that we represent, the big name industry leading technology companies, some of which, work very close to where you're sitting, Wayne, over in Silicon Valley. But as I mentioned earlier, because every company has an online presence now, every company is investing in technology to run its business. Our skill sets as lawyers apply to a wide and diverse client base. We represent, as you said, the small companies who are operating at the startup stage with hopes of becoming the big name tech companies 5-10 years down the line. We represent entertainment studios, and entertainment companies that work here in Los Angeles, particularly as they venture into the new world of internet video streaming. We represent companies that sell consumer goods over the internet. Fewer and fewer people are going to the mall. More and more are buying their clothes and goods and electronics online. This diverse client base, in my mind, keeps our practice here at Wilson, kind of fresh and new and exciting every day. So it's very interesting, and I truly enjoy having that wide, diverse client base that is afforded an internet strategy litigator.
So look, the three of us understand the difference between working for a big brand name and an emerging company. Those are wildly different client experiences. The legal work may be more or less sophisticated on either side. It's not necessarily easier, but it's different because of the size of the client and maybe the legal sophistication of the client. And I'd love for you to explain kind of the differences day to day. And can't tell from my tone of voice, I love working with small clients. It's tends to be more stressful because there's not an in-house attorney there. It's you and the CEO trying to figure out how to save the company. But I'd love for you to describe in your practices how that varies from client size to client size, and what a new attorney could look for, or what they could expect if they're doing both types or just one type of work.
It's like apples and oranges. Working with big clients, there typically will be a dedicated legal team in-house. We'll work with someone who reports up the chain and, has to go through multiple, let's call them, levels of approval to get things done. And sometimes that can work out to streamline things because they have a process in place. They've done this before. They're familiar with litigation. You don't have to explain things to them. They just understand it. They can take it and run with it. It can also slow things down. If there's any time a company gets to a certain size, it may reach a certain level of bureaucracy where it just gets harder to get, decisions made. It's harder to get a decision maker on the phone. And that part can be frustrating sometimes, but, it really depends client to client. In terms of the budget, that can also vary greatly depending on the client and their size. A small, scrappy startup with 5 or 10 employees is not going to have the same resources as one of the big names in tech. But working with small clients is at the startup stage can be really exciting because they're nimble, they're very engaged, they're hands-on. You're working with the CEO, the CTO. You are, getting into the nitty-gritty with them. And oftentimes that can help to understand the true business objectives and what is really important to the client. Because at the end of the day, the litigation is not always about the lawsuit itself. Sometimes it is to advance an interest on the business side. And, if it's existential, that can be a big factor as well in how you litigate the case. Maybe you give up certain aspects of it to focus on what's really key, to the company. But yes, it can really vary day to day. I would say that, I honestly enjoy working with both big and small companies. It's just a matter of, um, I suppose, tailoring the approach to the client in question.
So, Lisa, you mentioned just a brief bit of background on how you got to your current group, but I'd love to hear from both of you. How did you end up in internet strategy and litigation? I mean, I'm pretty safe in saying this. There is no law student ever that started their first day of class said, my goal in life is to end up in an internet strategy and litigation group, mainly because they've never heard of it. How did you get from the beginning of your practice to where you are now?
I will say that I myself did not know about the internet strategy practice of any firm, including ours, when I was a law student too. But I got into it by working with tech companies. I mentioned earlier, and you brought up, I started out as a patent litigator because of my technical background in the life sciences. Now, over the years, my practice naturally expanded to include trade secret issues and other types of complex disputes. But the common factor was that they all involve technology in some form. So from the very beginning, I've worked with clients to solve intellectual property issues across the full spectrum of technology. My practice has dealt with areas that range from AI-based malware detection to non-volatile memory technology to commercial drones to buddy blood testing and more. And through working on those matters, I started working with our colleagues in our internet strategy group and eventually made the transition over.
Yeah, like Lisa, I didn't know that there was even a such thing as an internet strategies litigator when I was in law school. When I graduated law firm, I worked at a different law firm than Wilson, but focused on kind of like traditional soft intellectual property litigation, primarily copyright and primarily copyright infringement litigation. And the pitch that got me to come to Wilson Sonsini's Internet Strategies group was this. I was told you can use that soft IP background, use it as a foundation, and then apply it to some of today's cutting edge issues in the internet space and in the technology space. And that to me was exciting. Because we're out there litigating on issues on technology and litigating on issues that take place over the internet, we are very often working on the forefront of the law, where there aren't easy answers, and where we kind of have to be creative and kind of try and see 5 steps ahead. And that type of challenge was something I wanted to do. And it's something that I feel lucky that I've been able to do for the past few years at Wilson.
So listening to both of you, it seems that some of you have tech backgrounds and some of you don't. Is that accurate?
I was an English major, so accurate.
Well, the reason I raise that is because so often I see students maybe self-screening. They're like, oh, this is a internet strategy group, so if I don't have a computer science degree or some kind of technical degree, don't even bother. And I don't think that's true, listening to the two of you.
No, I would agree with that assessment. I think unless someone is, let's say, drafting patent applications in a very specific area of the technology, I don't know that a tech background is necessarily, necessarily required. It's more, the ability to take technology, understand it, break it down and, apply the law and figure out what the solution is to the problem that we're looking at.
So with that in mind, if you were, and you will be talking to first year law students, their first year is pretty pretty directed. But as second years and third years, what kind of classes should they be looking at? Especially at Berkeley, we've got so many classes, but most law schools have a few. What kind of classes would you want to see students taking to get ready to work with you?
I think, all the core IP classes would be important, right? Copyrights, trademarks, patents, trade secret if it's offered. I know that's a more uncommon one to find. I think those are really important from my perspective. Russell, I think your experience was slightly different, so maybe you can weigh in on that side.
Yeah, I mean, there are no prerequisites needed in order to come here. If you haven't taken a class, we will not be, turning you around at the door, at the front door. What I would recommend is, particularly in your second and third year, take a few classes that work on litigation skills. So much of law school is classroom focused, and that is very important and very helpful. But very frequently, in your second and third year, the law school gives you opportunities to get a sense of what it's like to practice litigation. There's deposition workshops, there's moot court, there is mock trial, there are externships, there are internships. Do some of those. Take advantage of them because that will allow you to work alongside actual litigators, and that will allow you to kind of understand if litigation is right for you. And kind of once you have that underlying knowledge and have that underlying skill set, frankly, that's what you need to be in a group like this. I wholly endorse, taking those IP-based classes and learning as much as you can about that area. But I also, staunchly advocate for the idea that there is no one-size-fits-all way to get here. There is no one class that you need to take, and there is no road you have to go down.
Wonderful. The only place I might argue with you there, from my experience, is that anybody that's scared of evidence and civil procedure is going to have a hard time litigating. Those classes may not be the most interesting, but those are some of the biggest mistakes I've ever seen litigators and trial lawyers make. Missing a piece of evidence, missing a filing deadline, an appeal deadline. An associate that knows those rules becomes gold in a hurry. So just sometimes the foundations are necessary, or at least incredibly useful. Well, wonderful. I really want to thank both of you. This is, again, it's unusual, and for many, the first time they'll hear this type of information, this type of practice group. So it's really interesting to see an entire group focused in this area and kind of what that brings together in terms of expertise. And a lot of times, the more people you have in a group, the more chance there is to learn and accelerate skill sets. So it's a really interesting group for entry-level lawyers. So thank you.
Thank you, Wayne.
Thank you.